All right. Good morning. We are reviving our Wednesday webinar series. If you've been around for a while, you may remember a couple years ago we would do Wednesday webinars on a few Wednesdays out of the month, where I would take a topic regarding Social Security disability benefits and dive in just a little bit deeper, give us a little bit more time to talk about a specific topic. We took some time off, and so now we are back doing them again. If you have a specific topic about Social Security disability benefits, the application process, the appeals process, perhaps a specific condition, feel free to let us know in the comments below. That way we know what the interest is. Today we're going to do kind of just a broad overview of navigating SSDI benefits in 2025. That is very broad, and I think it will provide a good overview. But of course, we can't get into all of the specifics and the nitty gritty of all of the little details on such a broad overview. But we will go ahead and get started today. So again, if there are specific topics that you want to see covered, feel free to let us know in the comments below, and we will absolutely take that feedback and see if it's something that we can do. If you haven't attended a Wednesday webinar before, just like all of the videos, they're not intended to be legal advice. They're just meant to give additional background information. If you have specific questions about your specific scenario and want legal advice, I'll let you know how to reach out to us at the end of the webinar, or you can reach out to your attorney if you have one that you are working with. But so as the cover here says, is navigating SSDI benefits in 2025. So today we aim to give a little bit of guidance for Social Security disability insurance, which are SSDI benefits in 2025, covering the application process, and then also discussing some of the key strategies for successful claims. Real quick, I do want to note this is SSDI claims only. Okay, so today we're not really going to talk a whole lot about SSI, supplemental security income claims. Maybe that will be a topic for a future webinar. But today our focus is here on SSDI benefits in 2025. My name is Kaitlin Wildoner. I'm an attorney with Beacon Disability, where we focus on helping individuals prove their disability before the Social Security Administration so that they can obtain the SSDI benefits that they have paid into and that they now need as they are disabled and unable to work. So first, taking a look at SSDI as a program. As of 2024, based on statistics that are put out by the Social Security Administration, there are currently 7.2 million recipients of SSDI benefits. Again, that's as of December 2024. So now we are just entering April of 2025. So whether that amount has gone up or down in the last few months, I don't know. But that gives a broad kind of idea of how many individuals are receiving these benefits. Additionally, as of February 2025, the agency provided information that said that the average SSDI monthly benefit for the worker, so this doesn't include any additional familial benefits, but the SSDI benefit for the worker, the average amount is about $1,581. Now, that does not mean that that is close to what your benefit amount will be. Some individuals have a lower SSDI benefit amount, and some have a higher SSDI benefit amount. The benefit amount for SSDI benefits is based on your income and your paying into Social Security while you were able to work. So kind of along those lines, because it is dependent on your work history, in order to qualify for SSDI benefits, you do have to have a recent work history. So you generally will need 20 work credits from the last 10 years. So usually the way, if you call in, you talk with us, usually the way we kind of try to cover that is, have you worked 5 of the last 10 years? Social Security kind of tends to phrase it as working full time, but the 20 work credits are each quarter of coverage. And so each year you can earn a maximum of 4 credits or 4 quarters of coverage. And each work credit, the value varies year to year. But generally speaking, if you have worked and earned about $7,000 in 5 of the last 10 years, that should be enough to have that minimum threshold. SSDI does provide vital income for workers who become disabled, and the benefit amount is based on your work history and your medical condition. Now, that doesn't mean that somebody with a back injury may receive more or less benefits than somebody with a mental health injury, may receive more or less benefits than somebody with a autoimmune disorder. But what that means is your work history in your income that you paid into Social Security is what creates the benefit amount. And then your medical condition is what lays the groundwork and makes it so that Social Security is able to say, yes, you are disabled, or no, you are not disabled. So who qualifies for SSDI? So again, you have to have the work credits, the medical severity. There's also a duration requirement, and then there's a work limitation. So number one, the work credits, as we've discussed, generally speaking, will say you have to have worked 5 of the last 10 years and paid into Social Security for that time. So there are sometimes instances where people will start their own business and they might be working, but they're not actually bringing in any money and they're not paying into Social Security. So unfortunately, those years, unless you earn those 4 quarters of coverage for the year, are not going to be considered for the credits towards SSDI benefits. So you have to have 20 credits in the last 10 years. And generally speaking, you have to have 40 total credits. There are edits to this. If you are younger than 30, chances are you haven't worked 5 of the last 10 years, especially if you went to college or postgraduate education. So there are some different rules and ramifications for individuals that are usually younger than age 26, may still qualify for SSDI if you did work and pay into Social Security. But you do still have work credit requirements, but they're not those 5 of the last 10-year requirements. Medical severity. Your condition or conditions must significantly limit your ability to work. So you have to have, I spoke with somebody the other day explaining that because you haven't been able to work for the last 3 months because you had a surgery and are now going through therapy, hopefully the end goal is that you are better within 8 months. Unfortunately, talking to the duration requirement, your disability must last or be expected to last at least 12 months. So the medical severity and the duration requirement come in together, basically. Your condition has to prevent you from engaging in any type of substantial gainful activity, and that prevention has to either have lasted or be expected to last for a period of 12 months. Social Security often says that SSDI is not meant as a temporary disability, and kind of this beyond what we can talk about today, but that doesn't mean that once you're on SSDI that you get it for life. But what it means is that they won't pay SSDI benefits for a short period of time. That's not their intent usually. And so that's where that duration requirement comes into play. Also, kind of to that end, it doesn't specifically speak to the duration requirement, but it more goes to that it's not meant to be kind of a short-term disability program. SSDI benefits for majority of conditions are not payable until the 6th full month of disability. Okay, so that means that the first 5 months and sometimes part of a 6th, because they're looking at the 6th full month of disability, that there's no SSDI benefits payable during that time. If you are eligible, you may qualify for SSI benefits during those 6 months, 5 months, but really SSDI benefits start getting paid in that 6th full month of disability. And again, the disability has to last or be expected to last for at least 12 months. And again, the work limitation, the conditions have to be so severe that they prevent you from engaging in any substantial gainful activity. And I see here that I am blocking what that is, and it's $1,620 a month in 2025 for non-blind individuals. So if you are working, if you have a disabling condition that maybe makes it so you can only work part-time, and you are able to earn $2,000 a month on that part-time basis, whereas you used to earn $5,000 a month working full-time, because you're working and earning above that substantial gainful activity threshold, again, Social Security is going to say that you are not disabled according to their rules. Okay, so that's kind of a broad overview of who qualifies for SSDI. I also want to make a note. There's a lot, we've talked a lot about the work credits and the quarters of coverage and things like that. One of the ways that you can confirm your eligibility from that perspective is by logging into your My Social Security account. The Social Security Administration years and years ago, maybe it wasn't that long ago, it just seems like it, but they used to send out the annual statement, the My Social Security statement, that would show what your earnings history was and what you would be eligible for if you became disabled right now, what you'd be possibly eligible for upon retirement, and of course, what your earnings history was. They don't send that through mail anymore. Instead, that is accessible online through the My Social Security portal. So if you don't have a My Social Security account, I strongly encourage you to get one, especially if you're considering applying for SSDI benefits, as the agency seems to be making a push towards using that portal. So it's always better to be proactive and have it ahead of time instead of trying to scramble around at the last minute when you do need it. But that is a good incentive to create that account, because you'll be able to log in and see, okay, here's my earnings history. Yes, I do qualify for SSDI based on my earnings history. Or no, I don't qualify for SSDI because I only have 17 credits, whereas you need that 20 for recency. Okay, so that's another point on that. Okay, as I think I've alluded to, medical evidence is critical. With Social Security disability, they first look to see, okay, do you have enough quarters of coverage? Have you paid into the system? Once they get past that and you have, then they'll start to look at your conditions. And to do so, they will pull your medical records. So they'll pull records from all the providers. They should pull records from all the providers that you tell them about, including primary care, specialists, hospitals, clinics, surgery centers, rehabilitation facilities, physical therapy facilities, all of those. And you can see here, there's kind of like a little bit of a triangle. So the medical records as a whole are going to be the foundation of your disability claim. Okay. One of the questions, again, if you call in, that you'll hear us ask is, okay, do you have ongoing medical treatment? And the reason for that is because it is critical in a disability case. Social Security can't just take your word for it as far as what your limitations are. They need to see the medical evidence that exists. And so to that end, what can be very helpful are certain diagnostic tests, lab results, imaging, other clinical findings that have been documented by your care providers. On top of that, the treatment history, showing what you have gone through, what you have tried, different medications. I've had clients that can't take medication. And so instead of just kind of leaving it at that, their doctor puts in there and says, so-and-so is not a candidate for this medication because of this. And sometimes that can be helpful because sometimes you may have somebody reviewing your disability claim who knows somebody who has a similar condition, and that person that they know is fixed by taking medication. And that is not an option for you for whatever reason, or perhaps you did try that medication and either the side effects were too significant or it did not help. And so things like that can be very, very helpful to have documented in the file. It also helps to show and create a longitudinal care record to show what limitations you have, what conditions you have, and how all of that comes together to impact your ability to function on a daily basis. And all that comes together to prevent you from working. Finally, kind of at the top of the triangle is expert opinions. So if you see a specialist for your condition and they say that you are disabled and unable to work, it's not necessarily enough for them to just say that. Miss Smith, disabled and unable to work because of her rheumatoid arthritis. Social Security looks at that statement and they say, okay, we understand, Dr. Jones, that you think that Miss Smith is disabled and unable to work because of her RA. But we are the ones that get to decide that in this specific context. So what can be helpful instead is if Dr. Jones writes, Miss Smith is disabled and unable to work because of her rheumatoid arthritis. This is because she cannot, and then goes on to list your limitations, whether that's limitations with sitting, standing, walking, lifting and carrying, whether that's because you would need to be off task a certain amount of time due to your medications, due to your pain, due to your doctor's visits, due to infusion therapy visits, things like that, due to needing to take not just time off task, but days off of work. Let's say you've got a condition where you have to go for infusions on a 6-week rotation. And so in the 3 days leading up to the infusion, you are down for the count because your body is saying, I need my medicine and I can't function. And so perhaps you're in bed for those 3 to 4 days. And then you've got the infusion day. So now we're on day 4 or 5. And then you've got another 3 to 4 days after the infusion where it is kind of your body is readjusting to that. And so you're still back in bed. And then on day 4 or 5 after the infusion, you're able to get back up and start functioning again. So there we've got kind of a period of 7 to 9 days on an every 6-week basis where you're down for the count. And so having a medical provider kind of document that is your normal, that is to be expected, that can sometimes be helpful as an expert opinion. The Social Security Administration still doesn't have to pay heed to that and kind of use that as the gold standard, but it can be helpful in having the agency understand where you're coming from and why your conditions are disabling to the point where you are unable to work in any capacity. Okay. Medical evidence, again, is critical. It's crucial. Current guidelines do emphasize longitudinal treatment records, like I've mentioned, and functional assessments, which is the other thing. If you have a doctor who's kind of willing to say, look, based on, the examination that I've done, this individual is able to sit for 2 hours a day, walk for no hours, or no, sit for 4 hours, walk for no hours, stand for 2 hours. They can't lift or push, pull, or carry any more than 10 pounds on an occasional basis. And so on and so forth. There's usually limitations with bending, stooping, kneeling, crouching, crawling. There might be mental health limitations. There might be limitations on who you can interact with. There might be limitations on your ability to finger and to pick things up off of a table. And so those kinds of things all do come to play. And so if you've got a doctor who's willing to kind of put out there what they believe your functional capacity is based on their examinations and evaluations, that can sometimes be a helpful part of your claim as well. So here's the SSDI application process. So before you apply, you'll want to gather all the documentation. Collect any medical records you have, especially if you have patient portal access. That can be really, really helpful. Collect your work history for the last 5 years, especially if you stopped working recently. If you stopped working, maybe 10 years ago, there might be a little bit of a different timeline that we're looking at, but generally speaking, collect your work history for the last 5 years, and then your personal information. Of course, your name, social, address, date of birth, spouse's information. If you have a former spouse that you were married to for 10 years or more, or the marriage ended in death, you may want their information as well. Banking information, your routing and checking number, things like that. Just collect that. Have it handy in one spot so you can provide that information to Social Security. You don't need the actual medical records at this point, but what you'll want is at the very least a list of all of the doctors, hospitals, and clinics that you have been seen at with respect to your condition. I usually say for the year prior to when you stopped working through to present. That year before kind of tries to give enough background information to the agency, particularly if you kept pushing and trying to push your way through, trying to work, and then it just came to a head and couldn't do it anymore. But that can all be helpful. So at the very least, you want that list of facility names and doctors' names. You'll want the mailing address, the phone number, the first date that you were seen, the most recent date that you were seen, and if you have any upcoming visits. A list of the medications can also be helpful, as well as if you've had any imaging done, kind of what type of imaging was it, what body part was it done on, when was it done, where was it done, other testing too, EKGs, ECGs, things like that are all relevant. Once you have that information, you can submit the application. You can currently apply online with the Social Security Administration at ssa.gov. If you have your My Social Security portal, that's where you'll go ahead and apply right in there. You can apply by phone, and you can apply at your local Social Security office. After you apply, the Social Security Administration will conduct an initial review. And so initially, what they're going to be looking at is that work history and the earnings history. They're going to verify your non-medical eligibility. They're going to make sure that you've paid into the system enough so that you would qualify if they find you to be disabled. Once they confirm that you non-medically qualify, that you have worked sufficiently in recent years, then the case gets passed off to Disability Determination Services, which is a part of the Social Security Administration, but they work for the state. And so that's DDS. They will then evaluate the medical criteria. They'll work with you. If you have medical records, they'll ask for copies if you can get it easily. If not, they do request medical records. And so that's what they do is they request the medical records, they review it. They'll also likely send you questionnaires. They'll want to know about your day-to-day functioning. If you've applied and have alleged any type of pain, they may also send a supplemental pain questionnaire, a supplemental anxiety questionnaire, supplemental cardiac questionnaire. I'm trying to think of some supplemental headache questionnaires. There's a lot of specific supplemental questionnaires that they may send, but they will almost always send an adult function report. And that is where you can tell them, I kind of call them testimony without having to go before a judge, because it gives you an opportunity to explain to the Social Security Administration what your functional limitations are as a result of your conditions. So on those, they're not necessarily concerned about your diagnoses and the terminology, but what it is on a day-to-day basis that you go through. Once they've received all of that and they evaluate it, you will receive your initial decision. Right now, we're seeing those take about 8 to 12 months. Of course, it can vary. It varies on the state. It varies on a lot of factors, but that's kind of our general timeline that we've been giving. Some come back faster than 8 months. Some are taking longer than 12, but that's kind of a broad brush estimate for what we are currently seeing. So some common pitfalls that you want to try to avoid are inconsistent information. When you're providing information to the Social Security Administration, try to be consistent. If you tell them that you are disabled and unable to work because of your low back pain, but then on the adult function report, you are talking about that it's not your low back, but it's your knees. They're going to get that and they're going to be a little confused. So try to be consistent. Now, of course, that's not saying that you can't have low back and knee pain. You absolutely can. And it is possible, certainly, for you to start with low back pain and then knee pain gets added in. But if you totally ignore the back pain that you initially told them about, they may think that that's no longer an issue for you, when in reality it is. It's just you also want to share about your knee pain. So just try to be consistent. Of course, you can add things in. Our health is not constant. It's fluid. And so if you do find that you are having additional limitations after you have already told Social Security about certain conditions, you can absolutely include that in. You don't want to totally disregard what you've already told them about. The other thing is incomplete medical evidence. Sometimes the agency has a hard time getting medical records from one or more of your medical providers. If they reach out to you and say, hello, we haven't been able to get records from Dr. Jones, can you please help us? Do what you can to help them. Oftentimes it's just as simple as calling Dr. Jones' office saying, hello, my name is Ms. Smith. I wanted to call and check on my medical record request. The Social Security Administration says that they've sent it twice and they haven't received any records. Can you please confirm that that is in process? If for some reason Dr. Jones' office hasn't received it yet, they'll tell you. And then it's kind of being an intermediary a little bit. But at the end of the day, it's meant to help you. Also, if you have patient portal access for your medical records, go ahead and sometimes you can download those and then send those off to Social Security, and that can be helpful to kind of get around that as well. Missing deadlines is absolutely a pitfall you want to avoid. Calendar all response dates. Importantly, appeals are due within 60 days of the date of the denial. Some of the forms that they'll send you do have a 10-day turnaround time. Do as best you can to get them to them within those 10 days. If you need more than the 10 days for those forms, call and leave a message and say, hello, this is my name, this is my case number. I just received the adult function report. I am working on it. I see that the 10 days expires tomorrow. Can I please have an extension of 10 days? Usually they will go ahead and grant that without even batting an eyelash. Just be responsive. Appeals don't have that same wiggle room. They are filed within 60 days of the date of decision. As we talked about before, working above substantial gainful activity limits, which is $1,620 a month this year in 2025, is going to trigger an automatic denial in some cases. So you just want to be cognizant of that. If you do return to work and you were out of work for a year or more, there is still a possibility of turning your claim into a closed period for benefits. And if you have an attorney, I would recommend you speak with them. If you have an attorney and you're working, make sure that they always know that as well, because that may change things. And it's not something that we can do there's no wiggle room. If you're earning above that threshold, by the agency's definition, you are not disabled. So just make sure you keep in touch with your attorney about that. So a little bit on the application timeline. Initial application, like we said before, about 8 to 12 months for that initial decision. Reconsideration, again, about 8 to 12 months if that initial claim is denied. If reconsideration is denied, there's about a 9 to 12-month waiting period for the hearing. This varies widely throughout the United States. Telephonic hearings and video hearings versus in-person hearings also vary a little bit, because if you are in a busy hearing office and you are insisting on in-person, you may not get heard for a while, whereas somebody who's willing to do telephonic or video may have their hearing request from that same hearing office sent to a less busy hearing office, and so they get scheduled a little bit quicker. If the judge denies the claim, you can absolutely request appeals counsel review. And right now we're seeing about 6 to 18 months for that review process. All of these timelines, of course, can be shorter and they can also be longer. Prepare for a lengthy process. If you look at this, if you kind of look at the max time on all of these, and again, it can be even longer, but you're looking at, what is that, 4.5 years from when you apply to when you get a decision. Even if you're on the shorter end of that, you're still looking at about a 2-year process, assuming that you get approved at the hearing stage. So, our goal at Beacon Disability is always to get people approved sooner rather than later. But that, of course, requires participation and help on the other side, which is sometimes difficult to get. So it's not a quick process. That's something that I always talk about with people too when they call in, to try to manage those expectations. Unfortunately, it can be quite a lengthy process. Even if, I want to say this too, even if you have a doctor who says, oh, absolutely, you're a shoo-in, you'll get approved. You might get approved, but the tricky thing is a lot of the doctors sometimes aren't aware of all the nuances within disability law for Social Security disability. And so they see you and they see, yes, you're absolutely disabled and unable to work. But the agency might have a different definition than what the doctor is thinking of. So that's the important thing to remember too, is always to kind of manage those expectations and kind of plan for a long process. And if it doesn't wind up being long, then that's great. Because it is such a long process, some financial considerations, I always try to recommend people, if you have like a shorter long-term disability policy through your employer, to start with that, because that can sometimes get a little bit of money coming while you're waiting for the Social Security disability process. With respect to approval for benefits, your benefit calculation is based on your lifetime average earnings as covered by Social Security. And so again, you can I can't estimate what that amount might be, but if you go into your My Social Security account online, that should have a pretty close estimate before you apply. I have heard from some clients sometimes that when you have a pending application, you can't always see that information, what your estimated benefit amount would be. But before the process, you should be able to see that. Also, for health insurance, you become Medicare eligible 24 months after receiving SSDI benefits. So basically 29 months from your established onset date. And so what this means is not that, let's say you applied in January of 2022, you stopped working December of 2021. Okay. So you applied January of 2022, alleging an onset of January 1st, 2022, and you are finally approved in March of 2025. And so that is basically 2022, 2023, 2024, 3 years and 3 months minus 5 months for that 5-month waiting period. But you have passed your 29-month or 2-year waiting period by the time you get paid. So it's not, your 24 months don't start from March of 2025 when you're approved, but they start 5 months after your established onset date, basically, 24 months of payments. So you would get at least 24 months of back pay. And so your Medicare you'd be Medicare eligible pretty much upon approval, if that makes sense. Once you're approved, there are work incentives. There is a trial work period which allows you testing your ability to work. And then there are, of course, potential tax implications because the benefits may be taxable depending on your total income. I'm just a lawyer, I'm not an accountant. So I always encourage clients that have questions about that to please reach out to your tax professional, as that is a question for them. All right, so appeals. So your initial application is denied. What do? You file a request for reconsideration. At that stage, there's a complete file review by a new examiner who works for DDS. They'll request any updated medical records. They may send additional questionnaires to you for a better understanding of how things stand today. Because remember, these timeframes are long. So when you initially apply and you fill out that adult function report and possibly other supplemental questionnaires, things might change from then to the reconsideration stage. And so the agency does try to understand that. So they may send out new forms. They'll do a complete file review. If it's an approval, great. If not, it's denial. Then you'll request an administrative law judge hearing. Okay. Social Security doesn't really send out those forms at this stage because you have the opportunity to present your information directly to the administrative law judge. So the ALJ will have your medical records. You'll want to get updated medical records from when Social Security last updated the file to present, so that way they have a complete picture of what's going on. And then they will talk with you. If you have an attorney, your attorney may do some of the questioning, but they'll talk to you to try to understand what all of the medical records actually means for your day-to-day functioning and limitations. They'll issue their decision. Again, if it's an approval, great. If not, then you can request an appeal up to the Appeals Council. At that stage, they don't really do a whole lot of communicating with you. They will look at the file. They're looking to see, did the judge make errors that had they not made may have resulted in a favorable decision. So that is what they are looking at, not necessarily directly, are you disabled or not? They're more looking at reviewing the unfavorable decision to see, were there errors made that had they not been made could have resulted in a favorable decision. After that, if the Appeals Council declines to review, then you can certainly file an action in U.S. federal court. Attorney representation does tend to increase the approval rates at the hearing, and most successful claims tend to be approved at that administrative law judge level. You do have an individual judge that's assigned to your case. They allot a short amount of time, but still they allot some time to sit and listen. They've reviewed the file. And it's a little bit of a greater likelihood of approval just based on the way that the whole system works. So your path to SSDI benefits, document it all. Keep detailed records of medical treatments, your work limitations, and the communications. I always tell people, don't send the only copy of something to Social Security. Our phones nowadays are great. If you're going to send a function report or a supplemental questionnaire or anything to the agency, take pictures of it. Most notes app, I think Android does it too. I know iPhone can do it. And I know a lot of Android users will say, well, if iPhone can do it, Android could do it 5 years ago. You're probably right. And so, but yeah, take pictures and create it to a PDF. And just keep it in your email. That way you've got it if you ever need it. If Social Security says that they didn't receive it, you say, okay, not a problem. Can I fax it to you? And that way you've got the PDF right there. It also helps because if you keep a copy at the initial stage, you can look back on it at the reconsideration stage to remember what was going on then, how have things changed? Similarly, if you have a good relationship with your employer and you're considering applying, and your employer has told you, or you have an inclination that they believe that your functioning has had an impact on your work product, perhaps reach out to them, see if they're willing to write a statement about the way that they've seen your work product decline since your motor vehicle accidents, as an example. Let's say that, that brought on significant back pain and you've had surgeries and your employer has been trying to work with you, but they have seen a decline in your work product and not just in your work product, but in your day-to-day functioning. Before you used to be vibrant and now you've got to go take a rest every 20 minutes. So document all of that. The other thing that can be helpful, especially in claims for like epilepsy or migraines, is to keep a symptom log. And it doesn't have to be super detailed. Just keep it, contemporaneously with the time. I usually tell people print off, a free calendar from Google or go to the dollar store and buy, $1, $2 big calendar and just write, what your symptoms are each day. And that way you've got it for when you talk to your doctors. You're able to provide them with, true and honest information instead of just saying, well, I think that, I had 3 headaches last month. No, you can actually show them, okay, here's my log. I had a headache day 18 days out of the 31. That can be helpful. Be patient. I've said this before, the process does take time. Be persistent, follow through. If you think it's taking too long and you have an attorney, you can certainly reach out to them to see if they have any updates that might be happening in the background. If not, they may have tips on who you should contact once your wait time gets to be a certain point. Like I mentioned before, if you are receiving forms from Social Security that they are asking you to fill out, go ahead and do that. Again, most of the forms, they give about a 10-day window. If you get it on day 8, just give them a call and say, hello, I just received this. Please, allow for 10 more days for me to get this form filled out and over to you. And then, of course, seek help. If you think you need assistance, feel free to reach out to us or another attorney. We are here to help you. You can give us a call at 866-803-7734, or you can visit our website, beacondisability.com, for a free consultation. What we do from there when you give us a call is we chat with you. We try to understand what's going on, whether you are considering applying or you need to go through the appeals process. We have a discussion. We try to answer your questions as best we can, and then we lay out next steps. If it's something that we can help with, we'll send you an intake form and kind of get started through that process. If it's not something that we can assist with for one reason or another, we do try to point you in the direction of somebody who can, or in the direction of something that would be helpful to you. So that will do it for today. Thank you so much for your time and attention. If we can help, feel free to reach out to us. There will also be a link below on the replay where you can schedule a call with us if you'd like to do that. But feel free to give us a call if there's anything that we can do to help. We are here to help, something that we enjoy doing. And thanks so much for watching. Have a great day.